you eat, how much sugar they must put in your drinks, how much ounces they must give you for your lunch, which policeman must stop the car on the road, which lane you must drive in, which hospital and doctor your mommy and daddy must take you to. All those things, all those laws and regulations are made in your parliament. So we are very happy to welcome you here this morning. And I want to especially single out the teachers. I can't single out all the 120 students, but I can single out, I see we have 7 or 8 teachers here. Ms. Latoya Elliott, Ms. Christina Miller, Ms. Theola Brown Morgan, Morris Michael, Melissa Young, Clive Ludford, and teacher Jenny Piper. All of you, welcome, and for the work that you do with our kids and training those minds, we really salute you and say many, many thanks for coming to your parliament. Come as often as you can. This is your house. Come and learn from your small and teachers, use your experience to teach them. Welcome again. And I'm going to ask Senator Morris if he'd be kind enough to open in a word of prayer for us.
Thank you very much, Mr. Chairman. SIPA Committee at prayer. Eternal God and most heavenly Father, we want to thank you for sparing our lives to see this beautiful day. And we want to thank you for gathering us in this parliament to deliberate on matters relating to our country. We pray, O Lord, that you will send your sweet Holy Spirit to tabernacle with us and to touch our brain cells as we review this piece of legislation. Be with the chairman, guide him, protect him, be with the members of staff of the parliament and all the parliamentarians that are here today and those who are on their way. Be with the children, the students who are here from Clarendon. Guide and protect them and bless them and give them journeys, mercies as they return. Be with us in a special way, we pray. Amen. In Jesus' name, amen.
Right, students, I want you to recognize that every parliamentary session we have, we approach the throne of grace through prayer to ask the Lord's blessing on our gathering. And so that's a practice that we have in the parliament, one that I recommend that you use as often as you can as well. Welcome to my committee members. Just stepping out, MP Tony Hilton. We have two senators with us. I know I have some online. Senator Longmore and Senator Morris. We have online, this is a hybrid meeting, Member Donovan Williams, Member Dwight Sibbles, Senator Golden Campbell, Shireen Golden Campbell, and Member Julian Robinson, all online with us this morning. We're going to go through first of all, accept my apologies for starting the meeting beyond time this morning. I was one of those who were held up. Regrettably, I wasn't the only one, but I apologize that our meeting has started a little bit later than we would have expected. Apologies for absence. I see here we have Senator Dana Morris-Dixon and Member Tamika Davis. They've tendered their apologies. We have quite an interesting agenda this morning. We have 2 sets of presentations, one from the Development Bank of Jamaica, one from Lasco Financial Services Limited. But before that, we're going to get the confirmation of the minutes, which were circulated, and I will take them as read and ask if I could have a motion from Senator Longmore to move for the acceptance, and seconding. Senator Morris, will you second for us? Will you second the minutes for us?
I beg to second the minutes.
Thank you very much. Minutes moved and seconded. Any matters that you might want arising from the last set of minutes? If you have any corrections, then suggest them to us. Any corrections, please? No corrections, no matters arising. We move to new business, and the first item on new business is that the Development Bank of Jamaica will make a submission now to the Joint Select Committee looking at securities interests in personal property. Could the DBJ team identify themselves, introduce themselves, and then make the presentation? If you press that speaker item, yes, here you are. You're now able to speak to us.
Thank you, Mr. Speaker.
No, sir.
Chairman.
No bother with that here.
Thank you, Mr. Chairman.
I want to keep my visa. Just leave me out of this. No, I'm chairman of the Joint Select Committee meeting this morning.
Thank you, Chairman. I'm guided, and good morning to other members of the committee. My name is Adrian Nelson, Legal Officer at Development Bank of Jamaica. With me is General Manager, Ms. Sharon Henry, of the Development Bank of Jamaica, and also Ms. Shelley Ann Thompson. Behind me, also Legal Officer of the Development Bank of Jamaica. We are also accompanied by the members of the PC Bank, that's Assistant General Manager, Ms. Stacey Johnson, Assistant General Manager, Mr. Kirk Green, as well as Board Director and Attorney at Law for the PC Bank, Ms. Kemily McClymont. And I am also apologizing for the General Counsel of the PC Bank, that's Ms. Andy Williams, who is ill and unable to be here.
But you have whole lawyers beside you, man. We know them.
That's correct.
And before you continue, I'd just like to recognize that as well that Senator Fraser Binns is joining us virtually, and so she's online. Continue, sir, please.
Thank you. Thank you, Chair. So we have been asked to make a presentation on the Security Interest in Personal Property Act, and these are our comments. The Security Interest in Personal Property Act, otherwise known as SIPA, sought to implement a legal framework which modernized and improved the availability of domestic credit to the private sector, while effectively minimizing the risk of non-payment of loans. And access to credit in Jamaica is largely limited to only well-established businesses and persons who own real property or motor vehicles, traditional forms of collateral, both of which have titles accessible by the public on which an interest could be noted, and without reference to which title may not be transferred or an equitable interest may not defeat the secured creditor. Consequently, entrepreneurs and persons without access to traditional forms of collateral find it difficult to access financing and unlock investment for their business, which consequently stifles the growth potential, the economic growth potential of the country. An up-to-date secured transaction system ought to enhance and rejuvenate commercial activities. The objective is to streamline the process of using personal or movable property as collateral for a loan by a borrower. So SIPA aims to eliminate any uncertainties regarding the pledged property, the entity to which it was pledged, and grants the secured creditor the swift right to seize and repossess the property in the event of payment default. And the key principles of SIPA are the creation of security interests in various personal property, tangible or intangible, present or future, a clarification on priorities among the different claims by creditors on the secured property, public notification of security contracts, and enforcement by creditors of property rights in the secured property in a cost-effective and efficient manner. One of the weaknesses that we've noted is that the registration is neither constructive nor actual notice So the registration in SIPA is neither deemed to be constructive or actual notice. Section 48, subsection 6, reads that subject to the provisions of this Act, registration of a notice in the registry is not constructive notice or knowledge of its existence or contents to any person. Registering a notice, therefore, does not automatically equate to constructive notice or actual knowledge of its existence or contents. The use of SIPA is not so widespread across financial institutions or in the micro-lending space at this time that sees as a norm a reasonable person making checks with the registry prior to the purchase of most categories of secured property, especially those in a non-traditional form. So while we understand the reasoning behind the elimination of the constructive notice as it relates to interference with priorities, we cannot understand, or clarity needs to be had where it relates to the reasoning behind the elimination of actual notice. Because the effect of Section 48.6 has not yet been exhaustively tested in our courts, and the result may be that a bona fide purchase of a value without notice of secured property may take same free and clear. So, in other words, if you have a registration and SIPA in the registry, one would expect that that would amount to security and construe it as notice to the whole world that, you know, I have a security interest here, it's registered, and therefore that should give me some comfort in relation to the strength of that security. But the legislation as it currently stands is indicating that it is not really, it doesn't automatically override a purchase of a value without notice of the security interest. So our recommendation is that, you know, we could consider an amendment to mandate that purchasers of that actual notice, be required. So registration would constitute then, or be deemed to constitute actual notice that there's an interest in the secured property to the whole world. So the issue with the competing interest of a purchase of a value without notice would no longer arise. There is also a recommendation that an amendment may be made to mandate that purchasers of all second-hand goods with a value of, for example, more than 500,000 Jamaican dollars conduct searches at the SIP registry prior to purchase. I mean, the limit here is negotiable, but just some indication that at some point, you know, it's reasonable for you to make checks with the registry and make that a requirement. And also, we recommend that there should be no requirement to subscribe to the registry or create a client account in order to conduct a search, just to simplify the procedure. We, you know, as an alternative, we're recommending that the public be able to make searches with nominal costs for online searches payable by credit or debit card. So we're not saying that the searches should be free, because we know that the system has to be maintained and supported, but we could simplify the process in terms of access to the search.
I noticed that you say that the value is negotiable, and just looking at it and recognizing that we're dealing with SIPA, 500,000 sounds like you might have 6 items to be registered in the sector, because the point of SIPA is that you're dealing, except for items in the entertainment industry. But if you're dealing with real property or even movable property, then many of them will have a smaller value than $500,000. So I'm asking the drafters to take this into consideration, but I imagine a more appropriate value as the guide would be a lower value than one that sits here. This is done by banks who deal with hundreds of millions of dollars. So we need to look at a lower value to make this probably more realistic. But I appreciate what you're saying.
Certainly, Chair.
And I think the drafters are taking note about 48.6 as to how to do that, because it would see, that though seems to be a real area of contention, isn't it? Some thought and discussions will have to be had, especially with the practitioners like DBJ and banks, to come to some accommodation that has to be written into 48.6. But I leave that to you, drafters and lawyers, to deal with. Continue, sir.
Certainly, Chairman, that point is well received. I also would like to just draw the attention of the committee to Section 18, subsection 1 of the legislation, which speaks to a buyer or lessee of goods acquired as consumer goods takes those goods free of any security interest if the total value of the goods did not exceed $10,000 at the time the security interest attaches, or if there is more than one security interest in the goods at the time the security interest having first priority attaches. So that is some indication of the $10,000, that threshold there. It's at the time of the legislation, which perhaps could be used as a guide when we're making an amendment. Where are we now? Another weakness that we have identified is the insufficient provisions to prevent or deter disposition of secured property. A major weakness in the legislation is the lack of provisions to adequately prevent or deter disposition of secured property. The vast majority of personal property capable of a SIP registration carries no documented title and has no central register, which one must by law refer to in order to transfer full legal ownership. Nor does a SIP registration create same. It is therefore possible for a debtor to sell certain types of secured personal property to an unsuspecting and innocent bona fide purchaser of a value without notice. We recommend that where a debtor knowingly disposes of secured property without the consent of the secured creditor, where the security agreement forbids disposing of the secured property without consent, or the security agreement grants permission to dispose of the secured property, and the debtor knowingly applies the proceeds of that sale of the secured property in a manner inconsistent with the security agreement and without the consent of the secured creditor to so apply the proceeds, we recommend that these actions be the subject of a criminal offense. This recommendation is made as it is considered necessary to reduce the risk of the asset being put beyond the practical reach of the secured creditor, or to mitigate this risk. This would also add an additional obstacle to the endeavors of dishonest debtors, as the general public would be obliged to conduct a registry search.
Would there be any short for use of a shortage of a better word, would there be any sanction or problem if a person is required to make a search and didn't? Because if you're going to put in the requirement that a search must be made, then you have to say, if it's a requirement and you haven't done it, you have lost the right towards something. Member Hilton.
Chairman, I'm listening very carefully, and I think we need to be, I understand the issues that have been raised. I think we need to be careful about the direction I see we are going in criminalizing the activities. Now, I think the chairman raised an interesting point. I think there should be some symmetry in what is being proposed, because if on the one hand, I take the point about the notice and how that works, but to suggest that an activity that is commercial in nature and without, I think you made a connection with some fraudulent activities. But I think the symmetry is lost because what you're requiring that there be notice provisions to regularize or to set out the orders of priority. But as the chairman requested, there is no such similar requirement for persons who are accredited to do actual searches or to conduct searches. I think that we need to make sure that only for the most egregious conduct in what is, after all, a commercial kind of activity that we clearly set out the parameters before we introduce criminal sanctions and action inward. Fines, yes, and I appreciate that you really don't want a court proceeding that is long and drawn out, that is going to further add to the cost of the transaction. And so we may want to provide for some summary judgment or summary proceedings so that we can get quick responses. But I think we need to be clear about the parameters for criminal activities.
Indeed, what I want to add another perspective. You certainly want to make sure that people do not defraud the lender. That's the point, and clearly I understand that. However, to make that effective, the second part that you recommend is that there must be a search. When the prospective fraudster realizes that everything that is done over a certain value requires that a search be done, it's a deterrent. So you must make sure, I agree that you must make a search, but then if you're using it as a deterrent, whoever fails to make that search loses the right that they would have had.
This is particularly so in the context where I agree with you, we need to lessen the cost of the search. Right?
Yes.
We need to make it efficient, and we need to make sure that it's not, especially for those institutions that has to do many searches. It may be a deterrent or may impact the amount of search that is being done. So we need to look at how we can have arrangement for cost effectiveness, particularly in bulk transactions.
Oh, the financial institutions can do that, but the principle that I've just outlined is critical. Because it's very important that all those who are going to lend do that search, because you're dealing with small items, people who are generally outside the more structured and established arrangements to do credit and so on. So the search is a vital part of making sure that it works well. If you are required to do a search and you do not do it, you lose all your legal rights, and that must be written in there, because we want people to do the search, because it's part of what will make the system work better. All right, lawyers? Yeah. Right, so continue and...
Chair?
Yes, Senator, sorry.
Thank you.
Missed you there.
Thank you. Good morning again. I'm not of the financial banking background, and I'm trying to practically understand, in a real case scenario, the criminalization or the proposed criminalized offense that you are proposing. Reason being, on the flip side, where it says it would add additional obstacle to the endeavors of dishonest debtors and the general public would be obliged to conduct a registry search. There is a difficulty in my mind with mandated searches if they are not practical. And we are dealing especially with, especially because of the nature and the value of the products that we are looking at, it's persons who may not have that liberty easily. So in putting in a requirement like that, is there a conjunctive requirement or provision on your part to enable such searches? Or whose part? I am trying to get the practical understanding of it. Because, you know, we're dealing with money matters at the end of the day. And what may obtain for a particular entity that is equipped with certain resources to be able to comply might not be applicable, especially based on the value that we are looking at. So if I could just get a practical application as to what you're proposing, I would appreciate it.
Thank you, Senator. In relation to the online search, in terms of simplifying that access, perhaps the SIPA registry could do some sort of awareness in terms, and also make the process simpler for searches to be done for these persons who may not have easy access, right? And make this a subject of some awareness campaign or system. Yes. When you say curtail, in terms of that awareness requirement and access. Yeah, I have no issue, or we have no issue in terms of the providing online access. I don't know in terms of gauging the marketing awareness, how do you measure that?
All right, let me step in here for you. The ministry will absolutely make sure everybody does. That's what our job is. That's why I have these people over here, sir. And while she's not from the ministry, she's going to help us do it. She knows how to do it. She's out there every day. So you haven't been here at the previous meeting, so you would know that's a commitment that we will make, and clearly I understand how that has to be done, and it will be done.
Guided Chair.
There is, on this search matter, I think there's an issue here we need to ventilate a little more. Because my understanding was that when the search registry was established, there was the concern as well that persons who are just wanting to fish around for other persons' private information, to scandalize them and to do all kinds of things. In fact, I recall when the legislation was just done, that persons were finding out whose girlfriend and boyfriend was registering another vehicle or something for a person. It created quite a firestorm. So there is the concern about a privacy element in there.
I thought you were going to say there's a strong encouragement to clean up your act.
Yeah.
Is that?
There's that too, but I don't think this is a legislation to do this.
That's not what we do here.
I think we need to use some other. The church have a role to play, the social and moral mores. But fact is, in the search process, and the company's offices here, perhaps we should invite her just to say a little bit about how they've gone about the layers of protection, and whether, as is being suggested, we might have gone too far the other way, one way or the other, and we have not struck a balance between the facility, the efficiency, and the utility of the registry, as opposed to the layers of protection and access to information, and making it difficult. Have we gone too far?
Mr. Chair?
Someone online?
Yes, Mr. Chair. Donovan Williams here, MP.
Yes, MP Williams.
Yeah, so I would just like to ask the question,
Sorry, missing you.
Yeah, are you hearing me?
Yes, clearly now, yes.
Yes, I'm just wondering how that privacy element would be compatible with the principle of constructive notice. If it is accepted that once registration is noticed to the world, I mean, how would that be compatible with privacy?
The question is how the search will be compatible to a constructive notice and privacy. You want to try and answer that?
Meaning, yes, if it is accepted that, or it is established that once you register, there is an onus on the lender to carry out research, and there seems to me to be some constructive notice element already there. Now, how would notice to the world be compatible with privacy if you introduce, some element of privacy? The two are not compatible. I'm just asking a question.
Well, Member Hilton did ask that company office should look at it, and they might not be able to answer it now. You may want to answer it now, but it's something that you have to consider because you're going to clearly work out the compatibility between two areas. If you put on your mic, here you go, Ms. Sutherland.
That is so, Minister. We would have to have a look. Currently, what it is that we have a basic search that provides you with very basic information. And then you have what we possibly call a graduated search that provides you with more information and at which point in time you would have to have subscribed to the site, etc. So we would have to have a closer look at what is now being suggested as it relates certainly to the issue of constructive notice, etc. We do have some ideas because we do believe that the general public should have the ability to have certain information. Certainly, you should certainly know whether a collateral has been pledged, at least. And if there needs to be further information gathered, then there should then be that extended search. So we would need to look at it closely, Minister, before we proceed any further.
Minister? Just probably in conjunction with all that is being discussed, I think that as we are reviewing the legislation, we may want to, especially now that it has become such a paramount issue,
yes,
we actually define search. We actually define the parameters as was just indicated, because I think that is where a lot of the gray is in terms of how we might execute something like that. There's no clear definition as to what would be entailed in such search and the different graduated levels of it, if such.
Clearly, DBJ, your purpose is very well, sir, because as we craft this legislation, your kind of input is what we want. That forces us to look at any blind spots that might be in the legislation or something that should be improved. So thanks for that, and maybe it's time for you to continue with the rest of your submission.
Thank you, Chair. Insufficient. Another weakness that we find, crave indulgence, is a lack of a ready-to-use disposal option. So a secured creditor who has overcome the enforcement hurdles and now has possession of secured property is finally faced with the task of disposing of it. And this section does not refer to real estate, which has well-utilized and known options. We're talking about personal property. So auctions are currently held by various institutions in relation to property they have seized, or when seized through bailiffs or the court, then at the courthouse on a Saturday morning after enough stock has built up. Most existing auctions are tied to dealings with the singular institution orchestrating it. For example, courts or similar institutions. Individuals and smaller lending institutions likely feel uncertain about how to dispose of the secured property, as they would not be able to list the secured property at these auctions and may feel unsure of the costs associated with same. A recommendation in this regard is to modify the legislation to require the establishment of an online SIP sale page within the SIP registry. And this modification would enable individuals to employ various methods for asset seizure, followed by the option to use either a user-friendly online platform or participate in scheduled in-person or online SIP auctions. Promoting and establishing SIP in this manner would generate significant interest, encouraging its broad adoption among individuals, with expenses shared more widely among those not involved in regular sales. The expectation is that these costs would decrease.
That's an innovative suggestion to create the online marketplace and a role for the companies or for the SIPA registry in guiding persons to those sites. I think that is innovative and should be utilized.
As you can see, a piece of legislation like this creates opportunities for businesses that didn't exist before to come into existence and say, we can do this for you. DBJ, don't waste your time hiring more people. We have 6 people and 20 computers that will run this for you. Just give us a contract. As a Minister of Industry, Investment and Commerce, Senator Morris, I encourage new businesses, preferably to be registered on the Junior Stock Exchange. Continue, sir, please.
Thank you, Chair. As a result, everyone would have a more straightforward path from registering the security interest to the eventual sale of the secured property. Additional recommendations. We could incentivize institutions, for example, credit unions, PC banks, to use the collateral offered under this Act by offering an insurance regime similar to that of the Credit Enhancement Fund, in which approved financial entities can benefit from the additional security of such a fund to claim against in the event of default. And this would perhaps encourage the greater usage of SIP. A general public education campaign is also recommended on the purpose, use, and benefits of SIP as necessary in order to start a mindset shift from traditional collateral and conventional forms of security.
Maybe because DBJ is already in the business of providing this kind of guarantee, and you could then, you should be looking at maybe working with a private sector new company. Audrey could provide the joint venture capital, and you get set up somebody to do this for you with your guidance. So really, let us innovate as we go along. Let's not make it moribund and old. Let's create new places and get new businesses in the business. Continue.
And also, this will, well, I've indicated that. There are other sections to review as it relates to sections 28 and 30. The priority against other types of interest in secured property. It is recommended that these sections be reviewed given the ease of which a secured creditor's interest may be subordinated, otherwise defeated. And in conclusion, the SIP regime is not yet at a stage where it can stand on its own to secure an interest, of the type that you've spoken of.
Yes, it's going to need help from institutions like DBJ to get them established.
Yes,
Every
sure.
time you open your mouth, I put something else on your table. Continue, please.
So, for example, where the security is a motor vehicle, a lien is also registered as same will be reflected on the title. So all of the old practices are still deployed in addition to, or in some cases, instead of the SIP registration, where you have title, that is. So a reason for this is that the risks are lessened with the traditional security. And you have many of these institutions who are just not comfortable, with taking, securities that veer from traditional. So therefore, in this sense, this is still a problem that the legislation there has to counteract. This whole culture or mindset as it relates to the traditional security, which currently is just considered as far superior and just far secured. And those are recommendations.
Member Hilton.
I want to, I have to leave as I indicated.
Yes, I remember you said that.
But let me thank the DBJ for their presentation. I find that the responses have been they have some very practical responses. It is well thought through. I just want to make this observation, Chairman, and recommendation. Perhaps this is an opportunity for the DBJ. The development aspect of the bank has disappeared long time. And where there's a capacity and a knowledge base to help with streamlining a legislation like SIPA.
Is good development
Yes.
work, good developmental work.
Indeed.
You'll get them back into their work.
Yes, I think that is a contribution the DBJ can make to put back the developmental aspect in it, not so much finance lending in high risk environments, but to give practical institutional knowledge of the kind that you suggested around insurance and how that additional insurance and all that might be operationalized and make a contribution to what, from a policy perspective, we have determined must be done, because we simply cannot continue. I understand how secure people feel about land and houses and all these things, but we're not going to grow our economy if these are the only forms of security. And so other countries are doing it. Jamaica has to look in this area because it is one of the problem areas for growth and development of our economy. So DBJ, I'm urging Chairman, really with this institutionalized knowledge and information, can play a constructive role in helping to build out an ecosystem that allows for and assists the operationalization of a piece of legislation like SIPA. It needs your input, and the Chairman's remark about you playing this role, I'm just repeating that I think it is something that you should seriously consider, that the DBJ, with its track record, its history, consider that it has a developmental role in building out the ecosystem to underpin and to make operational a piece of legislation like SIPA.
You know, to amplify on the point that I made, and of course, Ms. Henry and others of you from DBJ know that I know the DBJ very well. What I'd recommend, General Manager Henry, is that you take this back to the board in this fashion. A lot of what we get now from multilateral and bilateral institutions like IDB, IMF, and so on, World Bank, is what is called technical assistance. If there's one institution in Jamaica that must do this, would be DBJ. DBJ, and I am talking to you as a minister, so I'm expecting a letter to come to me making the offer very soon. DBJ should cooperate with the minister, with the ministry, with the company's office, to say, as you put this together, we would like to render the technical assistance, which will come in the form of a grant. It's not a lot of money. When IDB gives us a grant, or the IMF, they give us a big grant, or the EU, we have to recognize these people, and we appreciate it. DBJ must now, in part of its development role in Jamaica, as we build out that MSME ecosystem, to get people, to get more ordinary entrepreneurs, and we're getting hundreds of them. I travel with them, and I took 75 people to Guyana. Maybe 30 of them are young entrepreneurs. Some of them are listed on the Junior Stock Exchange. DBJ must become the kind of technical assistant institution in Jamaica to help them, and a part of your budget should go to that. So I'm sending it straight to your board from Parliament, Ms. Henry. Glad you're here, and thank you so much. Please continue as Member Hilton takes his leave.
Mr. Chairman.
Thank you very much, Member.
Mr. Chairman.
Yes.
So those are our comments.
All right.
Chair.
Thank you so much.
Mr. Chairman?
Yes, I see. Is that Senator Fraser Binns?
Correct, sir.
Oh, come on in, Senator. Thank you.
Morning and good morning to the DBJ team. Are you hearing me, Chairman?
Very clearly.
Very well.
No.
Thank you, Mr. Nelson, for your presentation. And I believe, like my other colleagues, that the recommendations we're minded to give serious consideration to those recommendations. But I want to, with your permission, Mr. Chairman, just speak a little bit about the PC banks. You will recall at the last meeting that we had a presentation from the Ms. Pullen, representing the agricultural sector, and there were some concerns that were raised, and I too shared some of those concerns. I want to find out from your team, and I believe Ms. McClymont is there, the extent to which the PC banks, if any at all, have been utilizing the provisions on the SIPO, and also what, if any, outreach has been made by the PC banks to inform the farmers that this service exists. And I say that against the background that in all our meetings leading up today, what we have noticed is that though there are instances where the persons involved in the agricultural sectors have utilized SIPO, it has been quite nominal. I think it's 300 over the period from the inception of the Act until now. And the PC bank, which really is supposed to be the farmers' bank, in my mind, ought to be the lead agency advocating for the utilization of this act with the farmers. So I really would like to know the extent, if any at all, that the PC banks have been engaging farmers in the utilization of SIPO. And if so, what are the challenges that you have encountered? And if not, the reason behind that. So I will start with that, Chairman, and with your leave, I'd like to speak again. Thank you.
Right, and I'm, as a corollary to that, while you're going to answer, I have been getting very serious concerns, not even so much complaints, some of them were complaints, but serious concerns about the really relegation of the PC bank. There are many people who will tell you that they got their education because their parents were able to go to the PC bank and put in the title, and the PC bank was an active institution. In fact, they've never got to know the bank. There was none of these other big names that I may have been associated or other people may have been associated. They go to the PC bank. No, as I said, you know I know the DBJ. I'm not unaware of the issues with the PC bank, but Ms. Henry, again, speaking to you because you will have a direct access to the board, it is something that is coming to me as Minister of Industry, Investment and Commerce. As I take these roadshows, which I'm very pleased to say that DBJ is a main sponsor and IDB is our collaborator. In fact, IDB has given us $250,000 for the last set of roadshows that we've had, $250,000 US. So we are in good collaboration, but I must bring this to the DBJ because I know you have responsibility for the PC bank. It has been, you don't any longer have it, but you will find out who has it and bring it to them. Because it was resident at one time when I was used to it at the DBJ. But it needs to be brought up that the PC bank is an integral part of especially rural communities, and they are moaning and wailing that they don't have that access anymore, especially when some of those other well-established institutional banks are telling them not to come into the banks and go to ATMs that very often sometimes don't have cash. That is changing. Glad to see that. But the PC banks is an important part. And if you're going to have SIPA work, places like the PC bank now get on a new life to be useful in communities. So I'm asking that this be looked at as well, and especially in relation to what Senator Fraser-Binns just said. But I'll give you a chance to respond because Senator Fraser-Binns will probably want to hear from you. Press the button so I can let you on, and off you go. There you go. No.
Good morning again, members. I heard Senator Binns' question, and Mr. Chairman and other members of the committee, the reticence on the part of the PC Bank to take this form of security, and which is why we, in our wisdom, recommended perhaps the use of a guarantee like the CEF if we want the uptake or uptick in those non-traditional forms of security being taken by these institutions. In terms of the PC Bank, we had passed a law, I think the law might be about 5 years, Chairman and other members, and we no longer have control because they have paid us off, so we no longer have any control in terms of the management of the PC Bank and in terms of directing them as to how to govern.
Where are they resident now, Ms. Henry?
The Register of Cooperatives, sir. They are now at that's Mr. Gallimore, I think, who is the chairman. But, you know...
Excellent.
Yes,
Cooperatives
sir.
is in the Ministry of Industry, Investment and Commerce, so they're under cooperatives, no longer under DBJ.
Exactly, sir. Based on the legislation, and they have paid us out now, so we know when they had the loan, we would still have the priority, but now they have paid us off, we no longer have any control over them. And to just go a bit further, I mean, I've been at Development Bank for like 30, this year, probably about 38 years, and we have always had a good relationship with the PC Bank, and I know over the years, you know, the relationship has sort of dwindled, and I'm going to put my director, Senator Golden, on the spot. She's right here. She's not in management meetings with me, but I've always been at pains to say to management, you cannot terminate the relationship with the PC banks.
Thank you very much.
You must always maintain a relationship, because if we want to, you know, expand agriculture, the only institution with branches in every nook and cranny of the island is the PC Bank. And I've been at pains to my management from Milford and Reynolds days to say, do not terminate the relationship. They are an integral part of the growth of this community.
Stop right there, Ms. Henry.
Yes, sir.
You understand why I call her Miss Henry. Me know Miss Henry a long time, and she just like me. She call it like she see it. Keep calling me there. Somebody go, and especially now it's in my ministry. Well, Miss Allen, you better make a note, because you're going to have to work with me and the PS and the CTD and the cooperative society, because this, especially since SIPA is coming out of our ministry, we better get them tied together. And if necessary, we get the financial assistance from DBJ arranged, and IDB and wherever else we must get it from, but now it's our responsibility. Keep preaching, Ms. Henry. Let me hear what else you have to tell us.
So I'm just saying that to say that in terms of agriculture, we have to engage them. We must engage it, because we need to feed our people, and you see where the hotels are now asking for more food. So we need to reestablish, and I'm putting it in Senator Golden's lap to go back to the board to say what I said in this joint committee today.
You send her a note, you hear, so that she, because she's a lawyer like you, she will carry the message.
I know.
But I want to add that just yesterday, Minister Bartlett had his book launch. Prime Minister was there. Prime Minister has given responsibility to Mr. Bartlett and myself, and of course Minister Green, to make sure the linkages program work, and it should work well. The linkages program works, and it should work well to make sure the benefits that we're getting from those 3,000 stopover tourists, over 4.1 million, 3 million stopover tourists, 4.1 million when you throw in the cruise people, must drill down to the ordinary society, and that means a linkages program through farmers. So, Senator Golding Campbell, my dear friend, you will take that message back to the board that this minister will be quite willing to accept an invitation to hear how the board is going to work or how they want us to work with them. No problem, we will come. Continue,
Yes,
Ms. Henry,
so
and then Senator Golden Campbell.
I will yield to my director. And basically what I wanted to say was the reason why the PC Bank is afraid of taking these non-traditional form of securities like the crop lien. And you can recall, you were there with me during the sugar days, Chair. You know, we used to have, like, when farmers used to sell cane, and you know, if they know that they owe a debt to the PC Bank, what they do is sell it in the name of their neighbor, who is of course in collusion with them. And I suppose that is why we recommended the criminal offense, but I won't go down that road. But, you know, that is the reason, the reticence I say on the part. And the second part is for DBJ to establish a relationship with the PC banks. We are with them now with the dairy loans, which I think has now sort of died down now. But there must be some collaboration between the Ministry of Agriculture and ourselves, just like with the dairy loan where the farmers got subsidized loan. If we could get some monies from the government and put it to the PC bank so we can increase our agricultural output. So I yield now to my director, Senator Golding Campbell.
All right, and after Senator Golding, I'll have Senator Fraser-Binns come back in.
Chairman, yes. If I may, just to follow up on Ms.
Yeah, go right ahead, Senator Fraser-Binns.
Yes. And Ms. Henry, I can rely and depend on you to be as candid as you are. And I do understand, and I'm sure that when you speak to other financial institutions, they will tell you that challenge they face, not limited to our farmers. And it is, in my mind, a clear indication of perhaps a greater engagement with our farmers or anyone within the loan sector to ensure that there's a high level of compliance. And notwithstanding that, though, given what I believe to be part of the remit, and I'm very happy you mentioned the quest to have a greater relationship with the farmers. My question, though, is that, my thought, though, is that notwithstanding the level of non-compliance, and I'm going to come to the question, there is a clear need for greater engagement. So the question is, if you could share, I'm not sure if you're in a position to, and I do appreciate what you've said about the overall responsibility now moving to the Registry of Corporate Societies. But I wonder, though, since the inception of this act, if you could share with us, and if you don't have it, you can send it to us, the number of loans that you have and the percentage of default. And I ask that because in any institution, and I completely get it, that there is, whether expressly or impliedly, an objective for profit. But in any institution, you will have non-compliance. But at the same time, I believe that we cannot make perfection the enemy of the good. And as a result, there is a need for us to find within ourselves, perhaps the minister can set up a team if one is not yet in place, to look at how we can encourage greater compliance by our farmers. Because the SIPA was established for people like our farmers to ensure that they have that alternative. When the commercial banks don't want to give, they have this alternative. And if it is that they're not complying, what are the reasons for it? And how do we ensure that we have greater compliance? So that is in response to what you have said, which I completely understand and I accept, but I believe we can't make perfection the enemy of the good. And the question, therefore, is if you could share with us the number of loans you have and the percentage of persons who have been delinquent over time. And I accept you may not have it today, but it is something that I would love to look at, and that perhaps can guide our further discussion and certainly how we treat with this and other sectors, Chairman. Thank you.
We can get that data coming later on. What I'd like to do, though, Ms. Allen, you take this back to CTD, Franklin, and I'm going to ask you to coordinate, have her coordinate with Ms. Henry and Senator Golden Campbell to make sure that we now have at the ministry a closer collaboration with the DBJ, because I'm going to ask the DBJ to now infuse their guarantee insurance arrangement into the SIPA product that we're creating with this legislation, and make sure we bring into, for me to have a meeting with them and the PS next week, the cooperative society that handles the PC Bank. Because I was here still, because it has become so relatively dormant that you didn't even know it exists where. So that now I'm glad that it's clear where it is. So I want to have a meeting with them next week with the PS. Then afterwards, I'll push on with the Development Bank of Jamaica, because I want their development end to be tied into this, because what Ms. Henry so passionately described as a very important link in every community across this country is still there. And the passion that you brought to us a couple of weeks ago when you made your presentation, we have you back here again today. Oh yes, and please, tire in right away for me. Make sure she is involved in this discussion in the meeting I'm going to have at the ministry, so that we have that outline and ready, because one of the things that you will notice that will have to make this work, when you're dealing with people who are in an unstructured situation, they need closer supervision than those who are structured in, say, the JDF that has very clear reporting lines and you don't cross them. We're not dealing with JDF professionals. We're dealing with people who are essentially entrepreneurial and therefore free-spirited. So closer monitoring will have to be done, and we have to work that out as we put this together. Senator Golding, you've been very patient.
Thank you, Mr. Chairman, and I just want to welcome the DBJ team. I have been listening, and I've been on since the meeting started, Mr. Chairman, but as you know, I had to be in transit for a portion of it. I think Ms. Henry knows that at the board level, I have always been an advocate for DBJ's support of the agro-industry and the small and micro farmers. But I think it's important to acknowledge that the challenge in treating with the farmers, for all the reasons that have been stated. But in particular, Mr. Chairman, you made reference to our guarantee loan product. That product is delivered to the market through the private banking system. And a big part of the gap and the challenge that we have had at the DBJ, and we continue to grapple with it, is that there really is a reticence on behalf of the private banking system to engage farmers, small farmers, medium, micro farmers, because they don't necessarily understand the business. And so there is resistance to a farmer who is coming in. And I had a anecdotal story just this week about a farmer who's been in the business for a long time. He's in farming, he's in retail food establishments, and he wanted to borrow money for a tractor. The bank refused his, I think it was somewhere in the region of $10 million. And on his way out of the bank, he was stopped by a banking officer who wanted him to sign off on the loan that they had just given his wife for her new car. And he couldn't understand why the bank, same family, same business that was going to support the loan for the car was the business that they were refusing the loan for the tractor. So
can you get a reporter to report on that so it can be made clear? The bank's objective, I mean, this is the same man who's going to pay the loan. The tractor is what is going to make the money to pay the loan. And them can't get it in their heads. Them go for the wife's car.
He was at pains to explain that, Mr. Chairman. But it speaks to some of, and Member Hilton, I'm sorry he's not here, made reference to the development part of the development bank not existing anymore. And I have to, even in his absence, take great objection to that and to say very clearly and frankly that it is this type of background work, in fact, that the DBJ does, so that I know, for instance, that in this area, there have been discussions with AgroInvest, sits under the Ministry of Agriculture. The DBJ team, along with AgroInvest, has been trying to look at how we can offer to the banking industry the technical expertise to be able to assess these proposals when they come into the private banks, to allow the banks some comfort in granting loans and to feel that they're in less of a risky situation because they don't really understand the projects that are coming before them. And that work is ongoing. It's an uphill battle, though, I have to tell you. It is an uphill battle. But I agree with you, Mr. Chairman. It's something that we have to do. You know, the hotels, like Ms. Henry alluded to, they want more food. There is shortage in the hotel industry of
consistent supply of food, whole heap of food.
Yes. And they're not getting it out of the local market alone. So that's a huge area of opportunity for us and a huge area of opportunity for us to support our farmers and get them from the unstructured place to a structured business. That's some of the work that the DBJ is trying to partner with different entities, JBDC, to get them to understand financial statements, what it means to keep proper records of accounts, etc. It is being done, Mr. Chairman, not because you don't hear the noise out there, it is being done. But I wanted to ask a question of the team also, because as I listened to you coming down, it occurred to me that the question of registering the interest, a security interest, and having access to search a registry. What is the, if any of you know, and I don't myself, what is the connection between a property that has, if I own a property and it is collateral for some loan I have taken out, is there any record of that on my credit report? Because it occurred to me that when we talk about access and the concerns of privacy and so on, that perhaps a pledged property, my pledged personal property, ought to be recorded on my credit report so that a lender can ask me for a copy of my credit report or can pull a copy of my credit report, you know, depending on who they are and what access they have. Either I give it or they give it or they get it, and be able to see easily what my pledged property is, and to understand what's my level of asset and level of liabilities. That I have not deeply explored how that would work, but I wonder if that would be an easier way for those not so sophisticated lenders and borrowers to be able to know whether a property is available for securing financing or not. I'd love to hear your thoughts on that.
In terms of the information of that is to be on a credit report, my understanding is that I think it's the Credit Information Bureau Act. Those Credit Information Bureau may be able, I'm not certain, I can't say with any certainty, but they may be able to access the registry at the company's office. I don't know if there's a agreement or a memorandum of understanding between them. Probably the Companies Office could shed some light, but in terms of that, the Credit Information Bureau might be able to access that online registry. But with respect, Senator Golden, I think that would be more costly for anybody to get a credit report, because it does cost a lot to get a credit report rather than just going online, paying a nominal fee. And our minister has agreed that he may make it free to the public. So that I think that is the way we should go online.
Yeah, I want to make it, if I may interrupt you, I want to make it free for at least a period of time, and after that, a nominal charge.
Exactly.
Okay,
so.
we want people to do this well, so why are we going to build up a barrier? And if it's working well, and it's working well, and we have fees coming in, and people are employing people in jobs, the taxes are coming in. Make it free. But we start off certainly for free to encourage people to use it. No, I have to, of course, I come down here and make all these big speeches, and I have to go back and say the PS, try and find the money for me. All right.
Just in addition to that, Chair and members of the committee, the information that, one could access online on the registry, in order to protect confidentiality, it could simply state that, these are the number of security interests without giving the identity.
Listen, man, we're not going to make that fuss with us right now. There are lots, we've gone through this enough with the banks and everybody. You know how to protect people's identity. You know what to ask for to make your business work, and what not to ask for because you don't need it. Don't ask people for things you don't need to make the business work. Leave their private business alone. So I'm not going to spend my time here. We hire expensive people in banks like you to take care of that. So next one, please. Miss Henry will forgive me. She'll tell them to forgive me because she knows me very well.
On, Senator.
Any other comments? Company office? Ministry, any comments before I move to the next? I see a mic there on. Please go ahead.
Good morning, members.
Please remind us who you are again.
Kemily McClymont. I am Corporate Secretary and Legal Counsel at the
I think I've met you before, but just for the others.
Good morning, everyone. It's just to add to the discussion on the SIPA Act. It should be looked at in the context of going just beyond supporting lending activities, but the Act generally looks at also, in terms of protecting the secured creditor, it addresses how we deal with persons seeking to buy assets. So while the Credit Reporting Act may assist lenders, when you have persons trying to dispose of their assets, the SIPA Act and what has been recommended is a duty be imposed on persons who are looking to buy those assets, to impose on them a duty to conduct a search. So the Act goes a little bit beyond just the arena of lending solely, but deals with transactions on a whole as it relates to the secured interests. All right? That is my 2 cents. Eh?
Right. Any other comments? Then all that's left for me to do is to say to DBJ, thank you so much for your very well-received presentation, and we will be working with you to make sure it works. You don't have to leave. I'd love you to hear what Lasco has to say, because they probably will bring up your name. I hope they do. Yeah, before you leave. So the next presentation that we'll have is from Lasco Financial Services Limited, and I'm going to invite you to introduce yourselves and then make the presentation for us. I need to see somebody plug their mic so I can let you on. Oh, okay.
Not on.
Here we are.
Yes, it's on now. Yes. Good morning, Chair, members.
Make sure you speak in the mic because they're recording you upstairs.
Okay. Good morning, Chair, members of the committee and colleagues. My name is Ricardo Thomas, the Assistant General Manager for Lasco Microfinance, and with me is my colleague, Mrs. Juliet Campbell, Operations and Customer Experience Manager at Lasco Microfinance. We are honored to be invited here to give feedback on this act, since Lasco Microfinance has been one of those core lenders providing access to financing to the core microspace.
And a major supporter of the Ministry of Industry,
Yes.
Investment and Commerce MSME roadshow across the country. They've been at all four of them with us, and we expect to see you again in the future. So you and DBJ have been there with us, and we thank you, so continue.
You're most welcome, sir. Lasco Microfinance is a subsidiary of Lasco Financial Services. We provide loans, personal and business loans. We are located at, our head office is located
Okay,
at
I was
12th
just about to
Street.
tell you that you have 45 seconds for advertisement.
Yes, yes. So yeah, take every opportunity to share. Our head office is located at 12 Duke Street, and we have 9 branches across the island. We provide on the business side, Senator, Chair, we provide micro, small, and medium-sized loans for financing to expand operations in various ways. And in doing that, one of the core space that we serve is the informal micro business, informal space. And when we talk about informal space, we're talking about those customers who oftentimes are not registered. Those customers that keep very little, if any, records at all.
Right.
And who I believe this act was targeted to provide them with access to financing, while provide a framework for lenders also to reduce or minimize the credit risk. To serve in this space since 2020, we have provided roughly 5,000 loans valuing over 900 million to these core micro enterprises, informal persons. So we have quite a bit of experience in terms of the risks and of this space, the opportunities that this space, and how the act and how we have been navigating lending to this space with the act and with the NCIP registry. I will be speaking, Juliet and myself will be speaking from our experience with the act and how the act has supported us in providing access to credit to this space. We have been using all the customers that are in this space that try to provide collateral. We definitely utilize the registry to register them, to be able to do searches to see if they have access to financing or use loans elsewhere, if that collateral. And we do this in support along with the credit reporting to see who else have interest in that collateral that they are intending to pledge or has pledged, and so on. So we find the act very useful. However, there are some challenges that I heard the DBJ spoke of that resonate highly with us also. Because when you look at the core objectives of the act in terms of persons being able to register that interest, persons being able to see it, and so on, one of the things I can tell you as the lender is that while we want to provide access to credit, we want to also minimize that risk, that credit risk in the event of default. And when we choose to access or utilize this form of collateral, and without these movable shuttle, the appliances that the customers may have, even talk about agriculture, we have farmers who will come into us also to seek financing. Some of the challenges we find in the non-traditional type of collateral being pledged is the lack of a proper title. So as the members from DBJ had mentioned, what that results for us is that we can have on our paper that we have these collaterals in place, but they're so easily transferable that in reality, they're non-existent. So unlike with motor vehicle land, etc., where your lien, your interest is properly noted and it can't be transferred, without you being aware or party to that, with this type of collateral that the Act is, trying to open the door for the customers to be able to utilize these form of collateral to get access to financing, we find that is not as effective or as we would want or would rather, for the mere fact, as I mentioned, that one, it is very easily transferable. The other thing that we note also is that, and I heard it came about that website, and we were chuckling to ourselves and we were laughing about it, because that is something we have been discussing about how is it, with a motor vehicle you get an independent evaluator. It's very easy to determine the value. Land, similar. With securities, persons of pride, stocks, etc., is very easy. The challenge for us is what the supporting operational framework or legislation that is needed to support this Act, to allow institutions to be able to easily be able to determine the value of any type of collateral that is pledged. And that is a challenge for us, because when someone, and a practical example, and we're speaking from our practical experience, when someone says to us, okay, I have a fridge that I want to use as, the first thing we have to say, okay, how do we determine the value of this fridge? The other thing that we have to look at, even with livestock, is that even if we get past that barrier, we will determine the value, and the person default, then we must be able to recover, dispose of it. Now, before you can dispose of it, you have to recover it, take it, you have to store it. And all of these there are costs involved in it. Not to mention, don't want even from Lasco Microfinance, from our space, don't want even to talk about the livestock, because where would we store that? Where's the type of support or framework to allow that? But in terms of the regular movable, non-movable shuttle, that you find the ordinary Jamaican microbusiness person, the bed, etc., the Act allows, and when you go on the website, you would recognize that the site allows persons to register without having a serial number. Now, if there's not a serial number, then how do we able to trace that particular asset that has been registered? So that is a gap that we saw in terms of the operational framework to implement the Act here on the website. It allows you to register assets without mandating that serial number. Because as an institution, that is one of the first ways, any asset we're going to hold or register, you must have that unique identifying number, which is tend to be a serial number. So that exclude things, certain furnitures, your bed, etc., that can exclude it. The other thing, as I mentioned, is oftentimes, and we're talking about the practicality of the Act, well, a customer may have their appliances, but you find one thing is to be able to determine that value initially, to see what we call a loan to value, what is the value acceptable in terms of the loan. But the other thing that you also have to look at now, how do you even account for depreciation at the time to realize when you decide if you want to dispose of it? So there are some additional, whether it be through legislation or operational framework, that would be required to support the practical implementation or greater utilization of persons being able to use collateral, non-traditional collateral outside of land and all of those things to be able to get access to financing. Oftentimes, what we find is there's also supporting need would also be greater marketing or public awareness for persons to understand the importance of even storing receipts. One of the challenges we find, someone would always have their title, so it's easy to show proof of ownership. Another challenge we find when persons say, yes, I have this, and you go to the home, you realize, and you say, okay, can you prove ownership for this asset? They can't. They're having challenge because oftentimes the proper receipting to prove that, okay, this is actually mine and not my neighbor that I borrowed for the purpose of this loan. So that is also a challenge that we see or we experience in trying to utilize this type of collateral as security for the loans. I mentioned already storage, because when we take an asset, when we say a loan is secured, it's not just in theory, but it means that if this customer defaults and we have to recover and dispose of this asset, we should be able to. And a key part of it is the storage of whatever asset that we, especially the type of assets that you find that the ordinary microbusiness Jamaica, the ordinary person will have is mostly the appliances. They don't necessarily may have the land, the house, and they're not going to have financial instruments, and so on. And even if they have a motor vehicle, oftentimes that motor vehicle is very aged. Right? So you find appliances that is there. Now, one of the things we have to account for is the rapid depreciation of this type of asset. See? So whatever framework that's supporting for us to be able to find institutions accepting and utilizing and providing the access to financing that the Act is aiming for, the objective, because while we're here, I was going back through the objectives of the registry. And I say, okay, it sounds good, and so on, you know. And yes, it achieves some of the things that here, but for it to achieve it, we have to be willing to accept it, and there are other things that has to be accounted for. So yes, it is able to provide practical, effective, sustainable system for publicizing rights to our lenders can determine that if an asset. So yes, we can go today and determine if an asset, as another institution already has used that asset, or is currently being used. We're able to do that, but we have to first be able to comfortable, really to accept that asset. And to accept it, we have, you know, that type of supporting, as I mentioned, and a colleague earlier from DBJ mentioned, is be able to determine the value or having a schedule, because we're not evaluators, and that now become a very subjective activity, because different institutions are a debate between yourself and the customer as to what this thing is value at. You know, somewhere now, a platform that will allow you to can easily dispose of it. Otherwise, what you're going to find is that you're going to have a storeroom full of appliances, etc., that has a rapid depreciation, and then the storage costs exceed the value of those that you have. So then that does become now what we call good collateral on our books. It will look good in theory, but in practicality, when we look at accounting for potential for loan loss, etc., then we can't really use it. So that is one of the other things that I mentioned. But there are some recommendations. I know I went through some of them, but I heard a colleague at the beginning mention about how do you deter persons from transferring it outside of your knowledge. And that is something that we also, you know, were prepared to make recommendation as to what kind of legislative support can be brought in place to deter persons that when they pledge an asset, because we may find some non-movable, that movable asset that we can take, like, you know, we may find heavy equipment where someone can pledge, and that is good. But it still has the issue of not having a proper title. So there need to be deterrents, some framework or something needs to be there to deter persons from being able to move that, to sell, to dispose of that, to transfer ownership without the institution's knowledge. And that is one of the things there. I spoke about the valuation system or something that should be required already. And I want to speak now in terms of the operational platform, which is the NC platform. So part of our process is that we go and view any customer that comes in. We want to be able to assess that customer properly. So we'll go on the platform to see if this person have any other facility, anything that they have pledged. But what we find on the platform does not make it mandatory. It's not mandatory for like the TRN number. So a recommendation we'd like to make in terms of the operational platform is that the TRN becomes mandatory when someone, because when you type in a name, a name, you may, for example, there may be 10 Ricardo Thomases, and that comes up, and then the search result also does not necessarily contain the TRN either. So it makes it a bit challenging to be able to ensure that the person that you intend to search for is actually the person result that you're seeing. Another area on the platform...
before you move
on.
Clearly we're moving closer to the national ID. which will have a lot of information that people will have. Who will have access to that information? That's going to be the question that will be asked. Yes. And the security arrangements, the legal security arrangements that are imposed for the security of information, who will have access? So those will have to be worked out. But they're worked out. When people want car loans, them give them TRN, isn't it?
Yes, yes.
So we'll have to work it out to make sure that that kind of information is secure, though. Otherwise, it will be an issue.
Yes. Yes.
Continue, please.
Another gap that we found is when you are registering that asset, it asks for a lapse date, which is normally the maturity date. What you find, though, when you do a basic search, if that loan has passed the maturity date, if that customer is in default and that are delinquent, even if not necessarily in default but delinquent, and that loan now is going past the original maturity date, when you do that general search, you do not see it. You have to do an advanced search to be able to pick up. You have to do you have to know what is called an access number. So if there can be some modification to the platform which allow the search when you type in that information, that basic information, that it brings up the full information for the cost. It brings up that customer even if the maturity date has passed. So what happens now?
Are you using maturity date interchangeably with lapse date?
Yes, sir.
So maybe you should use lapse date because maturity will sound like a loan.
Okay.
Lapse is when the certificate is no longer valid, isn't it?
Yes. Because the lapse date, when we're entering, what we recognize as a lapse date is that maturity, because you do not expect to have interest in that asset beyond the maturity date. So that is also a recommendation there, Chair and members. Our experience with NCIP overall from its inception, from where we've been doing now for quite a while, we find it is useful. It is very useful for us to be able to determine if a particular collateral, if other institutions have interest in that collateral and the history of that also. So that has been very useful. But as I mentioned, the other thing that I spoke about, I believe can have greater value for you to see institutions, financial institutions, be more comfortable to provide greater access to financing for who this act is seeking to target. I was very pleased when I heard the talk about the guarantees in terms of, how guarantees can supplement or complement, the whole NCIP registry, because what we find is that the guarantees, especially like the CF, seem to be tailored more around the SME, not necessarily the micro. It's tailored around the SME space and not the micro. Now, I believe that if we're serious about providing greater access to financing for the micro, then a similar guarantee facility needs to be looked at. I have had meetings with the IDB and the World Bank through the DBJ to try and put that out there, because there will be cases where the asset that the customer has and have in their possession will just not meet. It could be an old, but yet you would love to be able to provide lending still. So that complementary, support in terms of a guarantee, we believe could also go a far way in allowing institutions to be more comfortable to provide access to financing.
Chairman, with your permission, can I just say something about the guarantee for the microfinance?
Please, Ms. Henry.
And as usual, I'm glad our senator, who is a director, is here, because she chairs the Rio Tinto Trust Fund. And I'm sure it offers guarantees to micro enterprises / micro farmers. I'm not too clear here, but certain here rather. But I think it's limited to 3 parishes, St. Anne, Clarendon, and so here's a limitation. So, but we do offer. So to say that we don't, it's not entirely correct. I don't know if the senator wants to come in at this time.
Might I? Because I must tell you, we have had an extremely frustrating experience with even the microfinance institutions on the Rio Tinto Alcan Legacy Fund. The fund provides a substantial guarantee for farming businesses in those 3 parishes. Excuse me. And we can't get any of the micro lenders to lend under the fund. It has been almost 9 years. And we have certainly, I know, in the last couple of years since I've been chairman, we have had extensive discussion with the banks about the guarantee that is offered under the fund. And we just can't seem to get them to budge. We cannot seem to get them to understand the role that they need to play. And you know, without beating up on the banks, I find myself repeating that too often when I'm in this chamber. The business of banking is a business of risk and risk management. And so it can't be that banks are waiting for 100% guarantees in order to do business. There has to be, we have to put them under pressure as well, Mr. Chairman, to acknowledge their role in coming to the table, assessing proposals, measuring the risk, and putting out products that take into consideration that risk, cost it, and put it out there. But there is, I believe, a certain amount of, if I can use the word, laziness to engage in that way, because the truth is our banks have largely become risk averse. But the business of banking is about risk. So it doesn't make any sense.
I have a suggestion for you, and this one is very easy for me. We talked earlier when DBJ was presenting as to how we're going to make sure people know, and I made a commitment that the ministry will be leading that effort. So here's how we go about it. DBJ develop the product. If it needs some adjustment or tweaking for this SIPA, get it done. We, as I said, I've just asked my ministry to coordinate with you anyway, so we're going to know. When it's ready, the first port of stop will be the unregistered, the informal lenders, if you will. You allow me to use that term. The non-banking lenders, okay? Who lend to the micro borrowers, the MSME kind of people. We get it to them, explain it to them, make sure they understand and want to make it work. Then the DBJ hosts all the banks, invite me as the minister who is responsible for SIPA, and make me sell it to them, because I've created all kinds of lending programs that have made my banking shareholders very wealthy. So them can't tell me any foolishness. So, but let's go to the people who lend to MSME and the PC banks. We get them in one room, and it might not be one meeting, and we get people in there who will train them. JBDC have that facility. We get other people. DBJ develop the development part of their business that we talked about earlier to train people like these, because you're not going to have branches around Jamaica. Here are your branches. So you get what you do though is you hire the people who can train these branches, if you allow me to use that, around the country, and you don't have to go out there, go set up a brick and mortar, it's there. But you need some kind of brick and mortar in the countryside, because then many of them not going on no line, nothing. You have to get them used to going online. When we get that done, then we move in on the banks, because now we know we have people who are going to use it. And these are people who I can talk to. I talk your language, and we say, hey, you're in the business of risk lending, and we understand. We don't want you to take risks that will make you lose money. But we have developed a product for you. We have even a possible guarantee around it. How are you going to create it and make it work, and what timeline are we looking at? And that's what policymakers will have to do to get policies to be accepted in the commercial area. My ministry is called the Ministry of Industry, Investment, and Commerce. This is commerce. So, Ms. Allen, you know, you have to take all them notes, because you know how serious I am about it. All right. So that's how we will have to get that. And the truth is, for a long time, banks never had to go out and make loans. We know what that brought us in the end. And we now have entrepreneurs out there doing it. They're doing more loans these days. But they really have to get down to, we don't do sugar anymore, not much. We don't do bananas anymore, not much. So we're going to have to do what people do. And you're a bank, and that's what we're going to encourage them to do. But we have to make it attractive for them to do. So let's make sure we create what we're creating well, which is the statutory arrangements that we're discussing right now. Any other comments?
Thank you for that, Chair. I will acknowledge the DBJ mentioned regarding the Rio Tinto, and we believe it's a very good initiative. There are limitations, though, to the activity that can be guaranteed, mostly tourist-related agriculture, and it's also limited to, I believe, 3 or so parishes. And these are because these are the old Mindow, parishes. So you find that it's not necessarily applicable, and the need for support for the core micro, I cannot be overstated there. Chairman, I welcome the suggestion that you made regarding how can the institution like the DBJ and others provide that support to financial institutions in terms of the development support. Because when any loan, any sector we're going to lend to, we have to fully understand the ins and outs of that and that activity, especially when it comes to farming. And so when that proposal gets there, that officer has to be comfortable, the institution has to be comfortable to be able to fully understand that and the risks involved. So that support, that type of arrangement where the institutions are involved, the DBJ and other entities are involved, so that we all sit and see what would make us more comfortable, and how do we bring the development aspect into it and combine with financing is very much welcome, sir.
Good to hear you mention farming, because my banking experience really covers the whole spectrum, including my last phase as an owner of a microfinance lending company that did a lot of lending to farmers in the 2000-2009 period when the world was going through a recession, a very difficult time. However, I have been in my last, certainly in the last year and a half or so, traveling to diaspora destinations, and the amount of demand that is there for, let's just start with orchard crops and mention ackee, avocado, mangoes, big investment, breadfruit, all orchard crops, but also for callaloo, for Scotch bonnet, for all the other stuff that dasheen and yams and sweet potatoes that the diaspora want. There is a tremendous demand. So apart from the fact that we bring importers to live right in here in Jamaica, and they're called hotels, because they earn in hard currency. And in addition to that market, which we want to grow the linkages in the country to make Jamaicans wealthier for dealing with the tourist industry, which is a ready-made market for us in the country. There's an overseas market that needs tremendous investment. And frankly, the financial institutions have missed the target when they have not financed these arrangements. And what does financing mean? if you're going to have an orchard crop of 500 acres or 1,000 acres, you're going to have water, a significant investment. You're going to have security. In the past, they have done this without security. Well, anywhere you have a property where people can pick avocado and eat it, or mangoes and eat it, you're going to have security. Another part of the investment. But the demand is so strong overseas that you can make it a profitable business. The financial institutions need to look at that. I'm working with Minister Floyd Green. We'll be doing some additional work on that, and with Minister Bartlett. But there are opportunities coming and that now exist that financial institutions need to look at. And, you know, I don't have anything against cars, but how many are you going to own? How many can drive at one time? Why are you going to own 6? So, you know, please get some yams and Scotch bonnet and red peas. We import, I don't know, we import maybe $300,000 or more every year of red peas. Why are we importing it from somewhere else in the Caribbean, and we can grow it here? Those are opportunities. So, Lasco, you're the one here today, and DBJ. There are opportunities. Go find people who will do this well and finance them. And DBJ is creating a guarantee that will help you. So, any other questions? No, that was my 45 seconds pitch, Lasco, okay? So we're equal. Any other, yes, please. Just recognize yourself for the party.
My name is Janet Pullen from the JA's office. I'd just like to add to what Chairman is saying, that when we look at the agriculture sector, and in particular, and you used one area, orchard crops, and we were talking last week about the whole matter of valuation. The agriculture sector is so diverse, Senator Golding, that when you look at a valuation of, let's say, an orchard crop, it is divided in so many sectors. And one of the sectors that we must look at when we talk about valuation is the environmental. Carbon sink, what monetary value that gives to a man's farm. How many trees, what type of trees? Because each tree captures carbon in a different way. And so it must be valued. So after I left here, I have had 2 internal meetings regarding the whole matter of
So you should come to Parliament more often?
to establish this valuation unit and what the unit should look like. And
you hear that? That's a new business being developed. Listen, financiers, a new business. Caller, how do I finance it? How do I secure it?
No, we'll be getting in touch with DBJ. We do have a good relationship.
I want them to call you. You mustn't. I don't want you to call them. They must be calling you. Go ahead.
Okay, but it's simple to say that when you in our negotiations and speaking with persons, they will tell you, but we have valuators. A land valuator does not embrace an agricultural valuation. An agricultural valuation embraces land. And so it's 2 different things. And I go back to orchard. And if you are able to finance an orchard operation, you cannot lose if it is monitored properly. And we will speak more on that.
Listen to me. Let me tell you something. Recently, I took a trade mission to Domrep, 35 or 40 people. I met the former president, who is called the agriculture president. They export over $1 billion in avocados. Me not talk about Jamaican dollars, US dollars, and more in mangoes. And me can tell you, say, them soil no better than ours. And we closer to the equator, we might even get more rain. So please understand what Ms. Pullen is saying. And Ms. Allen, I want you to make sure that when we have the meeting with the cooperative to look at what we're doing with the PC Bank, Ms. Pullen must be in the meeting. And my advice, when she gave her presentation here some weeks, maybe a couple of months ago now, everybody who was here and online as a member of this committee, them light up. all those you say you know DBJ, but Lasco, you want to grow your business and run ahead of the competition, you spend time with Ms. Pullen. Because what she's talking about now, the valuation of agriculture, and you get climate change in there and the carbon value of it, and what Matthew Samuda, my colleague in cabinet, is doing on the other side, these are values you can look at, and new businesses are being created. And we must create new businesses. So talk to her. That's why she's invited here today, to hear what you guys are saying and to add her input, for which we're happy. But agriculture is an area, because we've had such, shall we say, a mixed history with agriculture because of sugarcane and what it meant in slavery. We have backed off away from agriculture, and we have lost some of the steam. Well, we need to get it back. I was accused recently of somebody. I was speaking at a Rotary Club, and they say, you divested the sugar estate, and look what happened to them. I said, oh yes, you should be thanking me. I relieved the government of spending $5 billion a year to subsidize an industry that all it did was lose money. So now we're saving that and we're better off. So sugar is gone, but agriculture isn't gone. We must now revive that and get you financiers, get young people in there and say, this is where you can make money. You haven't gone out enough to look for entrepreneurs. It's the entrepreneurs that going to build your businesses. If you have the money and you can't lend it, you're not making any money. Not those times are gone, because high interest rates are gone. So make sure you work with entrepreneurs, work with the Junior Stock Exchange, work with people who are at CASE, and even at the University and UTech and CMU, who you should be encouraging to get into agriculture, especially after you talk to Ms. Pullen. That's another 45 seconds. So, ladies and gentlemen, do you have, my colleagues online, any other comments before I close this session? Well, thank you both so much, DBJ and Lasco, for coming and sharing your insights with us. You have clearly educated us and challenged us to make sure the legislation we're preparing will be even better than we thought it could be. So thank you so much, Ms. Pullen, all the people who support us from the ministries and the legal eagles that come from all the places that they come from to be with us in Parliament, my colleagues on the committee, Ms. Cohen, our clerk, thank you all so much. And when is our next meeting? It seems as if the tentative date for the next meeting of the SIPA JSC is the 25th, but that will be confirmed by Ms. Cohen. Thank you all so much, and I accept a motion from Senator Golding to terminate the meeting, and I'm sure Senator Fraser-Binns will support that motion.
I second it, Chairman.
Thank you so much, and thank you all again for spending time with us this morning.
I'm okay now.